Get ready for the dictation in 3, 2, 1, start. In Mrs. X versus Union of India 2017, 3 SCC 458. The pregnancy of the petitioner had continued up to 22 weeks when the fetus had diagnosed as suffering from bilateral renal agencies. The medical board reported that there was risk of fetal death, still birth, and no chance of long-term post-natal survival, and that there was no curative treatment available for bilateral agencies. The Supreme Court observed, thus, we have already wide order dated 16/1/2017, Meera Santosh Pal versus Union of India 2017, 3 SCC 462 upheld the right of a mother to preserve her life in view of foreseeable danger in case the pregnancy is allowed to run its full course. This court, in that case, relied upon S. Srivastava versus Chandigarh administration, where a bench of 3 judges held SCC P 15 para 22. A woman's right to make reproductive choices is also a dimension of personal liberty as understood under Article 21 of the Constitution. In these circumstances, we find that the right of bodily integrity calls for a permission to allow her to terminate her pregnancy. The report of the medical board clearly warrants the inference that the continuance of the pregnancy involves the risk to the life of the petitioner and a possible grave injury to her physical or mental health as required by Section 321 of the Medical Termination of Pregnancy Act 1971. It may be noted that Section 5 of the Act enables termination of pregnancy where an opinion, if formed by not less than 2 medical practitioners, in a case where opinion is for the termination of such pregnancy, is immediately necessary to save the life of the pregnant woman. Though the current pregnancy of the petitioner is about 24 weeks and endangers the life and death of the fetus outside the womb is inevitable, we consider it appropriate to permit the petitioner to undergo termination of her pregnancy under the provisions of the Medical Termination of Pregnancy Act 1971. We order accordingly, looking to the judgments of the Supreme Court cited herein above and in the facts and circumstances of the case, including inter alia the report of medical board constituted by the director Ames, we are of the view that the prayer of the petitioner deserves to be allowed. Accordingly, the petitioner is permitted to have her pregnancy terminated without any further delay. We express our appreciation for the assistance rendered to the court by the director Ames as well as the medical board constituted by him, who approached the matter with the urgency it deserved. The writ petition stands allowed in the above terms. Exemption allowed subject to all just exceptions. The application is disposed of. The appellant has filed this appeal against impugned interim order dated 3rd July 2020, passed in WPC 3784/2020, whereby the learned single judge has not been inclined to grant interim relief to the appellant original petitioner. The contract in question was awarded to this appellant original petitioner for manpower supply, which was entered into on 14th April 2020. As per terms of the contract, a performance bank guarantee of rupees 5,08,297 was to be submitted by this appellant within a period of 15 days from the date of contract, that is, on or before 30th April 2020. An application for extension of time to submit the performance bank guarantee was also preferred by this appellant, which was granted by the respondents even within the extended time limit. This appellant failed to submit the performance bank guarantee. Similarly, this appellant failed in making the payment of salary for the month of May 2020 to the workers. Consequently, for these two grounds, the contract was cancelled on 16th June 2020. Stop. Thank you.